with a couple that were going to want to do adjustment of status, but I learned that the foreign applicant originally entered as a K-1 visa holder, and the relationship didn't work out, so they withdrew their case. Unfortunately, their attorney didn't give them good guidance. Their relationship was amicable in the sense that the U.S. petitioner would have kept the affidavit support alive if they knew that it was allowed under matter of Sesay, which says that if you're on K-1 fiance visa and the marriage falls apart, you could still adjust status if the affidavit support is there. Now, whether USCIS will approve it, being relationships, all that kind of stuff, will yet to be seen. But that's matters to say. A lot of people know about that. But I was studying up on the law in this because you have a console. I'm going to get updated. So I went and studied like the 4 or 5 cases that were there, but some BIA cases, some federal court cases, and there was a case. And unfortunately, I didn't save the case to cite it, but it said that if you came on a fiance visa and you got married, adjusted, and then you get obviously usually you get a 2-year conditional green card. If the conditions on the green card are not met, conditional requirements are not met, you don't get a 10-year green card. You revert back to the status you had before you got the green card, a K-1. And then at that point, as the requirements are for the K-1, you can only adjust based on marriage to that original U.S. citizen. And so in these cases, if you get remarried or something like that, you can't adjust because you revert back to the K-1, which is, I guess, another negative notion part of the K-1 visa. It's like I try to avoid doing K-1s because of all the ridiculousness right now with the travel bans, for example. K-1 visa is not part of the exceptions that immediate relatives are a part of. So those people that did K-1 fiance visas think it would be faster. Got to get married now, file I-130s, and go through all that. And so that's the situation with K-1s I usually avoid. But sometimes there's some positives to it, I guess. But seeing that the I-751 denial reverts you back to a K-1 and you can only adjust based on the first marriage is such a weird situation that they did something like that. So what happens if you're still good with the petitioner? You then like readjust and file an affidavit of support, and if they're willing to do it, and you adjust again. Now, will they believe the marriage is real? Will they accuse you of marriage fraud, which is even worse kind of thing? I was asking ChatGPT about this, and it kept saying that although you can do matter Sesay and like submit an affidavit of support after a divorce happens, if the petitioner still allows it, in practice, USCIS doesn't really do it, and it's more of an EOIR thing. They're more amenable to it. But I mean, I haven't done a case like that, but I don't think that's necessarily true or not. So you got to be careful what ChatGPT says. And it kept saying like BIA decisions not binding on USCIS. Then I cited the 8 CFR section. We did an episode a while back where I definitely check it out. This episode didn't get many views, but it's like one of the most important ones. Let me find the number so you reference it. This is episode. Going back to my backlog on the podcasts. 8 CFR. It wasn't February. Essentially, I analyzed the 8 CFR section 103, top like 7 things you should know for USCIS filings under 8 CFR 103. And one of the notes was that USCIS is bound by BIA decisions, and so ChatGPT was saying that has to be like a recognized decision, but like matters to say is a recognized decision. That's case law. So, but I was surprised it said that. So take it for what it is. But listen to that podcast episode because it's really good. But just beware of this K-1 nonsense.